The clerk can go ahead and call the court to order.
The Court of Appeals for the 8th District of Texas is now in session.
Okay. Good afternoon. We're here on one case, cause number 08-19-216 civil, Kenneth Lyle et al. Versus Midway Solar et al. From Pecos County. Counsel, we can alert you that we have read your briefs. We have studied the record. We've already had a discussion amongst ourselves. If that helps you in the preparation of your argument, you will notice that there is a time clock that will count down from 25 minutes, and the lights are a little hard to see, but it will cycle to yellow when you're down to 5 minutes. And if you don't see that, I'll try and remind you if you go over time. So with that, Mr. Gaston, you may proceed.
Thank you, and may it please the court. Jeremy Gaston for appellants Kenneth Lyle and Linda Morrison, individually and as trustee of the Ruth Mary Lockbard Trust. This case at bottom is a trespass case. It's a case where one party, Midway Solar, has made such excessive use of the surface of certain property as to block all reasonable access to the minerals that lie underneath that property, minerals owned by appellants, thus constituting trespass in the form of an interference or obstruction or excessive use of surface easement rights. And those are the rights that mineral owners have, either impliedly or expressly. The ones here are express. And there are two key issues that I want to focus on. The first is, if a mineral owner, like appellants, finds that their access to the minerals has been blocked by an excessive surface use, must they nevertheless, and despite experts saying that there's no reasonable access, must they nevertheless go out and try to access those minerals before they bring a trespass claim for damages in our judicial system? That's the first issue. The second issue is whether the common law accommodation doctrine applies on any facts as a matter of law across the board to this case based on the 1948 price deed. Before jumping into the first issue, I'd like to mention a few points as to how we got here. Now, it's a long story in the sense that it dates back 70 years, but there are just a few really key facts to stress. The first is the 1948 price deed. In that deed, a group of grantors conveyed thousands of acres of property in West Texas, including the tract at issue here, which is approximately 315 acres in Pecos County. And in conveying that property, they reserved all of the minerals. And they expressly reserved a surface easement, giving them the right to use the surface of the property to develop that mineral estate. And they reserved the right specifically to take such, quote, usual, necessary, or convenient actions to develop the mineral estate. And the easement even mentions specifics such as being able to do all types of geophysical testing, for example. Frankly, though, most of the rights listed in the express easement would also be implied, even if they weren't there under Texas law. The deed also states that the mineral interest owners will have no liability for any damages to the surface or claim damages that have been said to claim to result from the usual, necessary, or convenient use of the surface for mineral development. Fast forward 70 years, and appellants are now owners with co-tenants of an undivided interest in all the minerals under the tract. And Midway Solar, before this case was filed in 2018, built and completed a solar facility. And the solar energy facility, if you look at it from the sky, almost looks like wall-to-wall carpet of glass. It's contiguous. It occupies approximately 217 out of the 315 acres. And the reason they were able to do that is because they leased the surface of the property from the surface owner, Gary Dergach, and the lease provides them 35 to 55 years of the ability to use the surface. They also got waivers of the right to use the surface, waivers of the right to use the surface by parties purporting to be owners of minerals under the surface, which, if effective, would have granted Midway the exclusive right to use the surface and not have to worry about mineral development on the surface. However, they didn't get any such waivers from appellants who owned the minerals under the tract. And the waivers they did get were all from parties, 20 parties, who don't own any minerals under the tract. The result is a tract of land where 70% is completely covered by solar energy facility, solar panels, and related equipment, leaving 30% at the 5% at the south end and 25% at the north end, theoretically available for mineral development, but as a practical matter, the 5% at the south end is too small to site a well under state rules. And even although the north 25% could be a place to site a well, half of it lies outside of the region that our oil and gas experts said is not the prime area for mineral development. In other words, if you look at a trend of where oil has been discovered in this region, you can trace a line and it goes straight through the center of the solar facility, but it doesn't go through that northern 25% except part of it. So all told, the vast majority of this land is inaccessible from the surface for oil and gas development. And more particularly, our expert, Bill Temple, specifically said that because of the geology and economics, you have to access the minerals here vertically through vertical drilling. So you need access to the surface rather than modern forms of horizontal or directional drilling where you can get to minerals that may be somewhere else by going at a direction or horizontally from the surface of land that's not covered. So that's the situation. And the first issue is, if something like that happens, do the affected mineral owners have to nevertheless go out and try and develop the minerals on the property before they can raise a claim in court for damages? Now, our position, of course, is that they can come to court and seek damages based on excessive surface use. And to be clear, they don't have, they being appellants, don't have current development activities or plans. And the basis is because they can't, because the surface use by Midway has obstructed that. But the reason they are able to still sue for damages follows from the basic legal principle that property rights are valued and protected, whether you are currently using them or not. And the easy way to see this is to think if the shoe were on the other foot. Suppose mineral owners went to their land where there was, say, nothing on the surface. And they went there and they dug up the land and they even built a house and things totally unrelated to mineral development activities. Obviously, that would be an excessive use of their surface access rights. Can the surface owner come in and file a claim for trespass based on their excessive use of the surface for damages? Or can the mineral interest say, well, you weren't using it and you don't have any plans to use it, so I can come out and do all of this that is excessive and otherwise unlawful? The answer is the surface owner can sue for damages. And there is no conceptual reason that we look at it differently when it's the mineral interest owner. Now,
Mr. Gaston, can you enlighten me as to how the statute of limitations would work in a trespass case? If, in other words, if you see someone trespassing on your property, yet you have no damages, does the statute begin to run at the time that you see the trespass, or does it begin to run at the time that there's an actual injury to you and your property right?
I believe that there are situations. I recently read a case where there was a trespass to the surface where this equipment was left on the surface. And someone came from several years back, and someone came and bought the property knowing that the equipment was there. And they were not allowed to make a claim because it had been there for so long. I don't know offhand whether trespass may be considered a continuing tort where you are limited in your damages to a look back period. So in some situations, you'll have limitations periods where maybe it's a 4-year period of limitations, but as long as the trespass is still there, you could look back at least 4 years. Limitations has not been briefed or argued yet.
I understand. I guess the question I'm asking you, and I'll ask Ms. Barron as well. The gist of Midway's argument seems to be that, okay, wait until you actually try and develop these minerals, and at that point you might be able to bring some sort of claim. And let's say you did that 20 years in the future. And when you did so, would you be subject to a limitations claim on the trespass? Would you be subject to some sort of, laches type argument, or even an adverse possession claim if you sat here for 20 years and watched all of this go on?
Right. And certainly we have listed adverse possession as one of the few examples in the law where if you don't use your property rights, you may find that they have been used out from under you, so to speak. And I think laches is a very general doctrine that could apply in numerous circumstances. So I would never rule that out as a conceivable defense. I think if a court said that the litigants here can't seek damages now, then I think it would be hard for a defendant later to raise a limitations claim because the courts have said they can't sue yet. So there would be some tolling, I would expect. In this situation, the facility was completed and the suit was filed, and so obviously there's not briefed or argued yet any limitations issue here. The question you pose, I think, is a good reason that you have to allow the suit. You have to allow the suit now because you don't want situations where someone sits around for 20 years and then raises a claim that could have been made. The answer is when they see the invasion of their property interest, and under Texas law, that would be the basic rule, the legal injury rule. When your property interest has been invaded, then the limitation starts running. That's the general rule, subject to tolling and other exceptions. So here we would say, if there was a limitations clock running, it would start when we were able to bring suit. We believe we were able to bring suit immediately, and that is consistent with the theory that the damages you get are the harm to your mineral interest as of that date of injury. So the value beforehand minus the value afterwards. And all
can I also ask, I'm sorry to interrupt you, but can I also ask, how would you ever prove, if you have no activity where you're seeking leases right now, how would you prove a measure of damage? In other words, wouldn't you have to show that, this much royalty payments are made, or this is the percentage, or this is the bonus payment that you get? But if you've never even gone into the marketplace and asked for that, how do you ever prove damages in this case?
Right. So in terms of damages, you could look at it in multiple ways. The people who own the minerals don't have to lease it. They could also develop it themselves. So either way, whether you're looking at the amount of royalties and bonuses you would get through leasing or the amount of profits you would make from exploiting it yourself, either of those would be bases for expert testimony where experts would go determine the reserves and the market prices and project it forward or project it in the market. I think the damages analysis would be pretty standard, but I don't think it's good. I don't think this record allows an inference that the appellants aren't in the market for any reason other than they now have an essentially worthless situation where, as our expert said, no reasonably prudent operator would lease the property and for mineral purposes. So the situation, in fact, on a damages level would be, what would this property be able to be leased for, or what kind of profits could be produced if the facility weren't there or there was reasonable access to the minerals. But back to the point about not being in the market, they're not in the market because they can't be in the market. The market has been taken away from them by the excessive surface use. one of the background principles here is that when parties such as a surface owner and a mineral owner have reciprocal rights, they're both able to use the same property, is the principle that if one uses it excessively to the detriment of the other, they become the trespasser. And that's the Brown versus Lundell case, which we've cited in our reply on page 5, note 4. And that really is a fundamental idea as to why you can go forward and seek damages. Now, the alternative, if you propose a rule where a party has to first go out and try and get their minerals, even though experts say it's not feasibly possible, is not only not in any precedent, there's no case saying that you have to have a current use in order to seek damages. And I should be clear about that. There's no case saying you have to have a current use or attempted use in order to seek damages in a trespass case. But the reason not to impose such a hurdle is all you're going to do is both encourage breaches of the peace, where someone like appellants goes out with a bulldozer and plans to build an access road through the middle of the solar facility. Obviously, there would be an injunction sought, and I'm sure the court would grant an injunction until it could look at the situation better. But if someone is seeking damages for the lost value in their mineral interest, why require the parties to go through injunctions or other outside exercises that are going to be futile? Because remember, at least by assumption, the minerals now are no longer feasibly accessible. So if that turns out to be true based on the proof at trial, Midway would owe damages. If it turns out not to be so by the proof, then they wouldn't. But in order to make someone do something futile before they go to court is also not a recognized principle in the law. Even in the context, say, of where people have to seek administrative remedies, there's always futility exceptions. The best case, I would say, because this is sort of a case of first impression, but the closest case is the Hopt versus Tarrant County Water Control District, where the Water Control District flooded the surface of property to make a reservoir, and that removed the mineral owner's ability to access their minerals. And the Court of Appeals, on remand from the Supreme Court, said that unless the Water Control District can prove that these mineral owners still have reasonable access to the minerals, they're going to owe damages for the value of the unrecoverable minerals. And the evidence, in fact, showed almost conclusively the opposite, the Court of Appeals said. And the only difference between our case and that case, apart from it being glass instead of water, is that there was a government entity as the defendant. And I have heard no argument as to why, whether it's a government entity that has harmed the property interest or a private party that's harmed the property interest, there's going to be any different analysis. The reason the Supreme Court issued a decision in that case was to say that if the accommodation doctrine applies with respect to the particular actions at issue, then you're going to use the private law accommodation doctrine, not any different standard. So there's no suggestion that there's any different standard. And there shouldn't be. When one party, whether it's the government or a private party, harms another's property interest, they should be liable for the harm that they caused, pursuant to a suit for damages, brought to enforce that upon proof that, in fact, the harm has been caused. The best case for Midway, I would say, is the lightning oil case. And as I'll explain, it doesn't fit here, but in that case, Anadarko prepared to drill a 8-inch diameter hole across land that was owned by, whose mineral interest was owned by Lightning Oil. And Lightning Oil sought to enjoin Anadarko from drilling that hole based on the idea that it might interfere with their future drilling activities. And the Supreme Court said, no, you can't get an injunction based on the speculation that what they do in the future might harm what you might do in the future, because that is speculative and not proof of an imminent irreparable harm. Here, however, what's at issue in this appeal is the propriety of being able to seek a damages remedy for the actions, not to enjoin Midway Solar, based on actions that have already occurred. Midway's already built the facility. It's not something in the future. And the proof that it has caused harm is not speculative. It was given with 2 expert affidavits, and none of that was factually controverted. And I should mention as a 4th point, it's even on its face, the idea that a 8-inch diameter hole across some land is a far cry from a 217-acre facility that completely covers the land. And more generally, cases like Lightning Oil do show that when you're not currently engaged in a competing use, or you don't have a plan for that immediately, injunctive relief is going to be probably not available. It just doesn't meet the standard for an injunction. But the standard for damages is, have you proven by preponderance of the evidence, or here, more than a scintilla because we're at summary judgment, have you proven that there's been a harm to your property interest? And if so, what's the value of it? Against all of this, Midway's one response is that this is an accommodation doctrine case, and accommodation doctrine cases require a current competing use. But this is not an accommodation case. We don't have a current competing use. We are not seeking to have competing uses accommodated. We're seeking to have damages remedied. And whether or not the accommodation doctrine applies, I think the basic principle, and you could sum up this case in this one sentence: you can't block someone from being able to exercise their rights and then say they can't complain about it because they're not exercising their rights. That's a catch-22, and it is not necessary to impose.
Counsel, if I could interrupt you again, I'm sorry, but I'm just trying to conceptually deal with this. I know you say the accommodation doctrine doesn't apply because of the express wording in the deed, but if you humor us to say that we might say that it does apply, I'm curious as to how a case like this would be submitted. In other words, you're going to submit it on trespass, and that has 3 specific elements. And then is the accommodation doctrine a separate issue that's submitted to the jury? And who carries the burden? Is it like an affirmative defense, and Midway would carry the burden on that? Can you comment on how you would submit this case?
I do think that at the present moment, it would not be permissible to submit the accommodation doctrine because they're not competing uses and they're not planned competing uses. And so the district court's opinion or determination that the doctrine necessarily applied here based on this deed would be an advisory opinion. But if it were somehow submitted, I think it would have to be a separate question. The question of damages is, did they excessively use the surface such that we have harmed property interest? And if so, what's the value of the harm? And the accommodation doctrine, it would be, are there reasonably available uses? It's hard to conceptualize. Are there reasonably available alternatives for the mineral owner to get all the minerals under the present state of affairs? Or one could view it the other way: are there reasonable alternative uses of the surface by the surface owner? It doesn't really fit into it, and it's because there's not a concrete factual conflict. But I can give an example of such a conflict and show why, for example, under this deed, a court would rule the accommodation doctrine shouldn't apply, which is horizontal versus vertical drilling. At trial, Midway might try and show that, look, horizontal drilling from the north 25 acres or 80 acres is available as a way to get to the minerals, and it's feasible, and who knows whether they could prove that or not. If the accommodation doctrine applied and they showed that horizontal drilling was feasible, that would be a question for the jury. Is that a reasonable alternative given the extra cost and so forth? But
so is your argument, just so that I understand it, I mean, aside from the language of the deed maybe expressly taking the accommodation doctrine out of play, that Midway had no evidence in the record that would suggest that horizontal drilling or some other, or moving their solar panels, that until they have evidence of that the trial court should not have adopted the accommodation doctrine because there's no evidence of an alternative.
Yes. In their motion for traditional summary judgment, which was their third motion, they asked that their actions be declared reasonable as a matter of law. They didn't submit any evidence in support of that motion. At the second volume of the clerk's record, page 1716, they stated without proof in another filing that horizontal drilling was available here. But again, they didn't make any attempt to prove that it was available or reasonable or feasible. And as an example, the reason I picked that example is because our experts showed that vertical drilling is usual and, in fact, the only feasible and therefore necessary way of doing it. And because the mineral deed here reserves the right to conduct usual activities, even if they are unnecessary or inconvenient, that would be an example where the deed shows that the accommodation doctrine can't apply, at least as between vertical and horizontal drilling. Even, in theory, it might apply for other choices. But that shows why it's a difficult issue to get into, and why we would say it's probably an advisory opinion to try and rule that it can or can't apply across the board as a matter of law right now.
Okay.
I know I'm out of my opening time, so.
Okay. Thank you, counsel.
Thank you.
Ms. Barron?
May it please court. The Lyle appellants are asking this court to go where no court has ever gone before, to be the first court in Texas to recognize a cause of action for damages by a mineral owner complaining about how a landowner is going about using his land when the mineral owner is not currently developing and has no plan to develop the minerals. And the court should reject this for 3 reasons and affirm the summary judgment on the breach of contract and trespass claims. And let me give you the executive summary of those 3 reasons first. The first is there's no remedy without a right. And what the right they're arguing for here is contrary to the express terms of the 1948 deed. It says you can only use the surface in conjunction with use of the minerals. They've conceded they're not engaging in use. The second thing is their argument conflicts with, and it's based on a fundamental misunderstanding of the accommodation doctrine. Under the accommodation doctrine, the minerals are always accessible. The end game there is not damages, it is development. So we want to maximize, we want to encourage maximum use of the surface when there's a conflict between severed estates. And so how that works is if the mineral owner if the landowner doesn't meet its showing, then they have to yield and mineral development goes forward as planned. But if they do, mineral development still goes forward, just in a slightly altered form that permits the existing surface use. So the end result is always development of the minerals. Access to the minerals is not lost, but you don't get damages. And then the third point is what they're arguing for has no support in Texas law. They're relying on the Hopch case. They're saying that's the closest thing they've got. I'll go into it more in detail in the body of my argument, but the 2 important distinctions up front are there was very active mineral development, not idle mineral owners like we have here. And second, it's a world of difference between a tort action or a breach of contract action against a private landowner and an inverse condemnation action against a governmental entity. If a governmental entity can't meet its showing under the accommodation doctrine and would normally be required to yield, it has an option that a private landowner doesn't have. It can say no. It can block development to protect the public interest. They are to protect the public water supply. But if it does that, it pays damages, not a breach of contract or some common law action, but under the Texas Constitution, Article 1, Section 17. So my plan is to just expand on those 3 points. But let me start by saying, trespass, they have the cart before the horse. You have to have a right before you get damages. And the right they claim here either has to come from the 1948 deed or the accommodation doctrine. And first of all, it doesn't come from the 1948 deed. As we just said, Mr. Durgach is the landowner. Under the 1948 deed, he has 100% fee simple interest in section 14. He lives on the north half. He leased the south half to Midway for solar development. And the Lyles are claiming that they own part of the mineral interest under section 14, both the north and south halves. And as you just heard them say, it's undisputed. They're not currently using the minerals. They don't have any plans to use the minerals. Any right they may have has to come by their reservation of the mineral interest in the 1948 deed. And in Texas, we don't imply rights under a reservation in a deed. That's the Perryman case from the Texas Supreme Court in 2018. It has to be express. It has to be out there in black and white. And they're saying,
Ms. Barron, excuse me. How do you answer the kind of what I would call the chicken and the egg argument? That their argument that I can't lease this property, I can't develop it because, you know, any landman who went out there and looked at it would say it's 70% covered by these solar panels, and I don't want to fool with trying to decide where I can drill or horizontally drill.
well, I think first of all, you know, until they come onto the land under the 1948 deed, it says they can only use the surface in conjunction with use of the minerals. And until that happens, Mr. Durgach can use his land any way he wants. And that's what Lightning Law says. And in fact, it rejected an argument very similar to this one, where Lightning Law said, our mineral interest is being devalued because of the actions of the surface owner and the surface lessee. And it wasn't just an 8-inch hole through the subsurface. There was also significant surface activities. They had a drill pad for 5 wells on the surface and plans up to another 60 wells after that. So there was going to be extensive surface use, and Lightning Law said this is devaluing our interest. And the Texas Supreme Court said Lightning argues we will depreciate the mineral estate's dominance and impair Lightning's right to use as much of the surface as reasonably necessary to produce the minerals in the future. We disagree. So one, it was rejected in Lightning. 2, it's based on that fundamental misunderstanding of the accommodation doctrine. Everybody knows at the end of the day, the mineral estate is the dominant estate and it gets to go forward with development. So for example, in the article, the law review articles they cite, not the law reviews, the CLE articles, I mean, they all recognize that development can go forward under the accommodation doctrine. And the solar development, if it doesn't get a waiver, does face risks that in the future there might be disruption or they might have to relocate some of their farm. And that's just the risk you take, but you can't always get agreement from the mineral owners. You can't always locate them because of fractionalized interests in Texas. And the third point on that, Chief Justice Alley, is that's the deal they made. That's what the 1948 deed says. It doesn't say you have the right to non-use of the minerals. It says you get access to the surface only in conjunction with use.
The deed, though, also kind of suggests that they could go out and just start removing anything that obstructs their ability to look for minerals and do so without damage. I mean, they would not have to pay you any damages if they went out and just took a bulldozer and cleared a path through the solar field. And so I think I'm hearing the argument from the other side that's really not a very palatable alternative for a court to suggest, that instead maybe trespass is I guess a more peaceable way to resolve this dispute.
Well, first they'd have to have the right to exclude Mr. Durgach from using his land as he sees fit. And Lightning, also rejected that, where they said Lightning was arguing that it should have the right to prevent any surface use that might later interfere with its plans. And the Supreme Court said, no, we're not going to change oil and gas in such a radical way. But The other point is that's how the accommodation doctrine works. As the Supreme Court's recognized, it's been tried and true for more than 50 years. These situations work themselves out. The developer comes in, they may put the stakes down where they're going to put their drill pad. The landowner objects. They either work it out amicably or they do it through an injunction. But in terms of their no liability provision, that's the common law in Texas. A mineral owner does not have liability to the surface owner for surface damage in conjunction with developing the minerals unless there's some specific agreement between the parties. And the Texas Supreme Court realized this. I mean, that was from the Humble Oil case in 1967, and Getty Oil was the big accommodation case 4 years later. So the accommodation doctrine was adopted with the background of knowing that the mineral owner is not responsible for damage to the surface estate. So let me expand a little bit on Getty Oil, because the accommodation doctrine really is bedrock law in Texas. Getty Oil came out in 1971. 3 takeaways are very important in that case that are relevant here. First, what I said at the beginning is that the minerals are always accessible. The end game of the accommodation doctrine is not damages, it's mineral development in one form or another. The second takeaway is the size of the project doesn't matter. They're saying we use 215 out of the 315 acres for the solar farm, but in Getty, it was even more extensive. There, the irrigation system covered almost the entire 128-acre tract, as the court noted in its opinion, except for a few corner areas. And the court said the accommodation doctrine applies no matter if it's sparsely developed, like open prairie land for grazing, or whether it's densely developed. And they gave some good examples. They said the accommodation doctrine applies to a residential area in the city of Houston. It applies to the UT Austin campus. It applies to cities, parks, lakes, prison lands, and industrial sites. So the size of the project has nothing to do with whether the accommodation doctrine doesn't come in and resolve the dispute so that we can maximize use of the surface between competing estates. At the end of the day, there's going to be use and there is access to the minerals. And then the third thing I want to say about Getty is, yeah, it has to be same place, same time. And that's built into the elements. This court had an opinion on the accommodation doctrine in 2018. Justice Rodriguez wrote the opinion for the court in Harrison versus Rosetta Resources. And in reciting the standard, you said that the first showing is that the surface owner has to show that the mineral owner's use of the surface or the mineral owner's activities on the surface are impeding existing use. So you can't get there until there's actual use and actual activities by the mineral owner on the surface. And Lightning Oil said that too. It said, you can't complain now. The accommodation doctrine, tried and true, will take care of that if there's a conflict in the future on how and where wells or well pads will be located on the site. And then,
is there a case that requires the, I guess, actual development or actual use that's a non-injunction case? In other words, if you take the injunction aspect out of it, where you have to show imminent harm, is there any authority that this actual use has to be ongoing to apply the doctrine?
well, it's built into the element, that first element, you've got to show there's a conflict. In Getty, it also says the second element where you have to show there's alternative means isn't abstract. You have to look at the circumstances of time, place, and use. So that shows they have to occur at the same time. But again, going back to the accommodation doctrine, this isn't a damage issue. This is, you got two forces and one has to give at the end of the day. So that's done by injunction. That's not by damages. So no, you would not have a damages case in this situation because mineral development always goes forward. It is the dominant estate.
So one of the elements or aspects of the accommodation doctrine that there's an alternative way to do this, whether it's horizontal drilling or whatever. Did you need to produce evidence of the existence of an alternative before the trial court could apply the accommodation doctrine? And if so, is there such evidence in the record?
No, because the burden never became ours under the accommodation doctrine. Because first, we have to show that their use, their actual use, their activities on the surface are getting in the way of what we're doing, not the other way around. So no. And what lightning oil says is we get to that when it happens later. So let me just.
And then can you address my question about if this happens later? Let's say we agree with you 20 years down the road, they decide they want to develop. What equitable defenses are they now subject to? Be it limitations or be it laches or adverse possession?
None. There are none because they own the mineral interest. They have the right to use the mineral interest. That doesn't change under the 1948 deed. And the accommodation doctrine, as the Supreme Court said, will take care of it when we get there. But at this point, until they exercise their right under the deed, they didn't negotiate for non-use. They negotiated for use of the minerals, use of the surface in conjunction with use of the minerals, not non-use of the surface in conjunction with non-use of the minerals. So, and they don't have a right to exclude Mr. Durgach from his own property. He can, they don't have a blanket easement. They can't come on here to have a picnic or hunt or fish or whatever. They can only come on for one purpose under the deed, and that is to actually use the minerals. And so until they do that, and until they've been precluded from actual use, they don't have a cause of action for trespass or breach of contract because they don't have a right to exclude and because their rights have not been violated. You got to start by looking at what rights do they have, not what damages or concern or complaint do they have. They don't have a complaint right now because they've never tried to access the property to use the minerals.
So, Ms. Barron, just as a follow-up to that, what would the evidence look like if they had exercised their right to use? I mean, what type of evidence might be in play?
I mean, it might look like they're affidavits now, but they haven't done that. We need to have a specific place and a specific time, because if they don't develop for 50 years in the future, how do we know what an alternative means should be? How can they dibs the surface now when they don't have?
I guess I'm trying to understand, because I know the argument is that it would be futile at this point. So you're saying, no, it's not futile because you haven't even taken any steps forward to engage in any use activity.
Right, correct.
So I'm trying to understand, well, where does that begin? Would they have to submit an application for development or hire a driller, or what type of evidence might satisfy that exercise of a right to use their property?
Well, usually you would get a railroad commission permit. You'd come onto the land, you'd stake where your drilling pad's going to be. You have concrete plans to actually develop. It's not, right now, we don't know, assuming we said, okay, come on in, whether they would be doing it 10 years from now or 100 years from now. But they're saying they get to dibs the surface now anyway, to the exclusion of Mr. Durgach, who is the landowner. He has 100% interest in this property. It's his property. And they can only use it. The bargain they made was they can only use the surface when they are actually using the minerals. They're asking this court to hold that they can get damages for not using the surface and not using the minerals. And back to the accommodation doctrine, they're saying it doesn't apply. Under Coyote Lake, it very clearly does. Coyote says it's the default rule. It always applies unless the parties have expressly addressed and agreed how to resolve the specific dispute by agreement. Has to be expressed. And they're hanging their head hat on the word usual. Okay, well, Coyote had very detailed, lengthy provisions about how the city could use the land for water wells. It said the city can drill wells at any time, at any location. It said you can do whatever's necessary or incidental to that. And the Supreme Court said, not express enough on where wells can be located. Right now, we don't know where wells can be located or specific locations. And more importantly, you know, usual is a lot like these other terms: necessary, incidental, useful, reasonable. But it also, under Coyote, it doesn't answer these questions. Does it tell us whether Mr. Durgach has to get their permission to use his own property? Does it tell us whether they have carte blanche to the entire surface, or whether they can dibs these broad swaths, decades, centuries before any development occurs? No, it doesn't answer that. That's too much baggage on one word. And HOP doesn't get them there. That's my third point. Inverse condemnation is completely different. If you look, they are relying on the Waco Court of Appeals opinion on remand from the Texas Supreme Court. Let's roll back. Let's look at the Texas Supreme Court opinion that remands it. And if you look at the next to the last paragraph in that opinion, in back-to-back sentences, it pretty much tells us what's what. At first, it says, yes, the accommodation doctrine applies under Getty. If the landowner can't meet its burden, then the surface owner must yield, and the mineral developer has a right to proceed. Mineral development always goes forward. But in the next sentence, the court recognizes that unlike a private landowner, government's different. It has options. It doesn't have to yield because it can protect the public drinking supply, which it wanted to do there, kind of an injunction saying, if you come onto our reservoir and drill wells, you're going to pollute the water. And so it was a taking for public use, and the damages there were not tort, they were not breach of contract, they were constitutional damages because a government doesn't have to yield under the accommodation doctrine, but private landowners do. The second point there is very active mineral owners. Despite the fact that the reservoir was in place, Justice Palafox there, they were able to get 2 leases, even though the surface was already covered with water. And they did go out, they got Railroad Commission permits to re-enter 2 plugged wells, and the city went out and got an injunction saying if you do your operations below an elevation of something like 350 feet, it's going to pollute the drinking water. And we don't want that to happen. And they also had tried to drill directionally from outside the footprint of the reservoir, and that hadn't worked. But they were very active. They were out there despite there being a reservoir there. They were still able to recognize they are the dominant estate. They get to go forward with development no matter what. Third, they're relying on the remand. Take a look at that. That's a very limited remand. It can't establish any broad propositions of law. The only thing was the factual sufficiency of 2 points, 2 findings in the trial court's findings of fact. It was all that was before the Waco Court of Appeals on remand. And finally, if you just fast forward 10 years later, same court, Waco Court of Appeals, one of the same justices, Justice Vance, who was on the HOP panel, writes the opinion in Texas Genco versus Valence. And there, the entire tract had been permitted as a coal ash disposal landfill. And the court held, yes, the accommodation doctrine does apply. And yes, here the mineral owner does have to make some changes, but development still goes forward. And I can't stress that enough. The access to the minerals is never lost under the accommodation doctrine. One way or the other, development goes forward, but it's not a damages result. I think unless the court has questions, I'll cede the rest of my time.
Can I just then ask you a very generalized question, but do these solar farms get along well otherwise in these areas where there is mineral development?
I don't know. That's not in the record. I think if you look at the 3 sale articles that they cite Ernie Smith's article and also the Sewell article in their opening brief and the Benavides article in their reply brief. All of these recognize the accommodation doctrine applies, and when and if mineral development occurs, then the solar developer is going to have to make adjustments. So I think those are the rules of the accommodation doctrine. The Texas Supreme Court has told us it's tried and true. It's worked for half a century, and it will work here when and if we get there.
Okay, thank you.
Okay, Mr. Gaston, do you have any rebuttal?
Yes, Your Honor. Thank you. I think it is the chicken and egg question here. And although the accommodation doctrine has been around a very long time, damages remedies for trespass have been around even longer. And the case law that we cite indicates that property rights, such as a surface easement, are valuable and protectable. And apart from certain circumstances like adverse possession, don't require you to use them. These property rights could be bought or sold or leased or developed. There are many ways in which they have value. And when another party, in this case, the one who's able to exercise the rights of the servient estate, so the Midway Solar operating on the surface is the servient estate to appellants who are the dominant estate with respect to the surface easement that they have. This is just a quote from the Severance versus Patterson case from the Texas Supreme Court in 2012. We cited our reply brief at page 18, note 46. Because the easement holder is the dominant estate owner and the land burdened by the easement is the servient estate, the property owner may not interfere with the easement holder's right to use the servient estate for the purposes of the easement. Suppose the surface estate had just built, suppose there are some roads on the surface estate and the surface owner had put trucks all along the roads. And suppose someone had a surface easement and they had the right to use the road to get from A to B on the land, but now they can't because it's blocked by all these trucks. Do they have to try and go through the trucks? Do they have to do anything? Can they, they might make a phone call and say, would you please move your trucks? And maybe they say yes, maybe they say no. Or can they file a lawsuit and seek damages for interference with their right? And if property rights only have value and are only protected when they are being affirmatively used, that would be one thing. But maybe an easiest way to see it, suppose this solar facility, instead of taking up 70% of the tract and leaving 5% unusable, and what was remaining with the surface area open was not in the most desirable. That's our situation. Suppose it had covered 99.9% of the tract. And suppose it had covered it with 30 feet blocks of asphalt to where it's so obvious you can't do anything here. Do they still have to go out and try? In our opinion, that's just a matter of degree. It's going to be far easier for that party to show that there has been an excessive surface use than someone where only 85 or 75% of the tract is unavailable or undesirable, which would still be easier than someone who, say, it only covered 15% of the tract. Those are matters of degree. Conceptually, though, under Midway's argument, even if the entire tract was completely covered in 30 feet of concrete, you still can't say my property rights have been trampled on. You have to try and use them, even though no one would even be able to give you a way to try and use them. Here, experts have said it's not feasible to go out there and try and get the minerals. They are valueless. They can't be leased. They can't be exercised. And so it is a chicken and egg. If someone can come around and, cross over your property rights, and their excuse is, well, you weren't using them. And even though you now can't use them, you just have no remedy. We did have a right. We had the reserved right to use the surface for such purposes as are usual, necessary, or convenient in the development of the mineral state. And now the experts say that right is valueless. And so it is futile. And while there may not be a case involving this situation, it's the rare situation where the entirety of a surface has been completely blocked for a contiguous acreage, which is why this is a case of first impression in that regard. An example, they say we don't have any damages and we don't have any rights. As a mineral owner, we have the right to pick where to put our wells. That was stated by this court in the Harrison versus Rosetta case, citing an older case, Gulf Oil versus Walton. The surface owner can't dictate where the mineral owner is going to put his wells. Here, that's exactly what Midway has done. Midway has dictated that any mineral operations have to be on the northern 25% or the southern 5%, according to their surface lease with their GAC. And the fact that they were purporting to limit where mineral owners can put their wells is one of the reasons we have the other issue about the cloud on title, where multiple parties purported to waive all their surface access rights except for some limited areas that Midway had unilaterally designated as the places where mineral development could occur. By purporting to...
if I can interrupt you, I did have a question about that part of your case. There seem to be three different types of waiver agreements. There's three different forms that were used. At least two of them would say, let's say I own all or part of whatever pieces of land we're talking about, and then they reference some other properties. I mean, isn't that basically, though, kind of a true statement? It's kind of like I say, I own all or part of El Paso County. That is literally a true statement because I own a very, very small part of it in my house. But I mean, how is that a slander of title when you have that ambiguity in what they're claiming?
Right, and that's a very specific situation. There are different categories of waivers, and of the ones that say that, they also, though, purport to reserve surface access rights to the limited tract areas that Midway had presented in this tract. And so they're purporting to give up all of their rights and reserve rights in this tract, among others, which I would say is an affirmative statement that I own those surface easement rights in the tract, even though they don't have any mineral or surface easement rights in the tract. So yes, in isolation, if you just looked at, I own certain interests in these lands that happen to include the tract. But then if you look at that in isolation, that would be one thing. But when you add to that, and I'm reserving from this waiver the surface use rights in these sections that are on the tract, that's when it becomes, I would say, the cloud that is purporting to not only limit the surface access of the mineral estate, but also purporting to put some of the surface access rights in people who don't even have it. Certainly, however, the waivers that said I own the minerals under this land are very clear, and I would say the worst clouds. And the ones you mentioned, I would put in the second category. But it's still a problem.
So maybe it's just a practical question, but it looks like at least at 2 points they tried to remedy this, either with their own disclaimer, and then also when the trial judge said, "Look, there's no problem here," but although he asked you to go back and and look at some pleadings to decide what the allegations were. But I guess it's more of a practical question. Why didn't y'all just sit down and draft a judgment that would have fixed this problem? I mean, don't you approve judgments as to form?
Yes, and my recollection, although it's not in the record, is that I don't believe the parties were able to agree on a form of judgment for this. Certainly, if they had agreed to a form, that would be what would be found. I think that's what parties generally try and do. I mean, the problem here is that the form of judgment, certainly the form of judgment appellants sought, was resisted by Midway, and that was a judgment quieting title in appellant's favor as against Midway and any of the other parties that were remaining in the case.
So on the waiver agreements, they went back and struck out section 14 and then refiled them. And your argument is that's a material change. Does this court decide that? Do we decide that as a matter of law, whether it's material or not?
Yes, the statute, Texas Property Code 5.028 and 29, have different provisions for material versus non-material changes. It doesn't define it. They both say including and give lists. So I think as a matter of law, a court looks at that and is going to have to say, is this material, is this non-material? Here's some examples. Does this fit within this or that? We would say this is closer to the add or remove land from a conveyance, which is listed under material conveyances. I would note that even 5.028 has requirements such as information from a person with personal knowledge to be added to the correction instrument. It has to be signed by all parties unless that is there, which is why the unilateral one wouldn't work even under that. But we would say it's a material correction because it's changing. In the example that I was just discussing, it's changing what's being reserved. The person, when they strike out section 14, that person is no longer purporting to reserve any reserved drill sites on section 14. And so the scope of the waiver is different. And that's not exactly the same as the scope of the property conveyance, but it's closer to that than a clerical name being misspelled or an address being wrong or something like that.
Okay. Well, I see I've drawn you off. If there's nothing further that you need to close up, I think we're done here.
Thank you, Your Honor.
Okay. There are no other questions from. Okay, great. All right. Well, thank both counsel for your excellent briefing and your argument today. Your case will be submitted on the briefing and argument, and we would have loved to have you in El Paso, and maybe someday we will. Knock on wood, cross fingers.
Yeah,
thank you so
exactly.
much.
Thank you.
Thank you.